This video may contain what could be considered attorney advertising under the rules of your state. This video is for information purposes only and should not be construed as legal advice. If you have a legal problem, it's vital for you to seek out and talk to a licensed attorney for advice. Good morning, good evening, good afternoon, wherever you may be. My name is Chris Simmons, attorney at law, and today we're going to go over a court decision that just came out, I believe it was earlier today, from the Northern District of California. This is a decision dealing with DACA, and I haven't read it yet. I understand kind of what the basics of it is, but I figure it would be best if we go through it together, and I can explain some of the things as we go through. I'm going to apologize in advance. This is all done in one take. There's been a lot of ambulances, a lot of fire trucks going on outside, and I live in a noisy building, so you may hear noise throughout the thing. That's kind of out of my control, but I do want to apologize for it since I am making this video all in one take. So let's start simple. Let's learn what we're dealing with. So this is the Regency University of California and Janet Napolitano v. United States Department of Homeland Security and Kirsten Nielsen. I do apologize. I'm bad with pronunciation of names, so I may mess that up. And you can see right here, this is what happened pretty much. This is an order denying Federal Rules of Civil Procedure 12b-1 dismissal and granting provisional relief. So let's figure out what 12b-1 is first, and then let's figure out what provisional relief is before we ever get into any of this. Okay, so I've already pulled up 12b. So Rule 12, this is the Federal Rules of Civil Procedure. These are, as it says here, defenses and objections when and how presented, motion for judgment on the pleadings, consolidating motions, waiving defenses, and pretrial hearings. Basically, this is all your motions. Most people are used to a 12b-6 motion. 12b-6 motion is failure to state a claim upon which relief can be granted. That's a pretty normal one. This one is for lack of subject matter jurisdiction. So let's figure out what subject matter jurisdiction is. Subject matter jurisdiction is essentially, does the court have the power to hear the case? So to break it down into a simple way, either it's a federal question, in which case there would be subject matter jurisdiction, or it's a diversity case. This one's not a diversity case, so it's federal question. I don't exactly know what they were trying to do with this motion, so we'll read into that and find out exactly what they were saying for why they might have lacked subject matter jurisdiction. But understand that these are responsive pleadings. They need to be asserted basically at the very start, at the answer of the complaint, essentially. So this is one of those things that you do at the very beginning, before you have discovery, before you have anything else. So this other thing, this other thing, provisional relief. Provisional relief is basically an injunction. And all it means is that there is likely to be irreparable harm done if we do not enjoin the parties from doing something. Essentially, provisional relief is maintaining the status quo. So it is not a judgment on the merits. Understand that. So it's not saying yes, it's constitutional, no, it's unconstitutional. It's not saying that the plaintiff will win or the defendant wins. It's just stating that irreparable harm will be done. So we're going to keep the status quo for as long as this this goes through. That's what provisional relief is. This isn't a judgment on the merits. So understand those two things. So with that, let's read through this together. I may skip small bits and pieces of it, but it is a 49-page. It's 49 pages. It might take a while. I might cut down on some of this depending on what it is, but let's at least get through this. So you'll have to forgive me. This is going to be a long video, so I may have to take some drinks of soda to get through it. So, introduction. In these challenges to the government's rescission of the Deferred Action for Childhood Arrivals program, plaintiffs move for provisional relief while the government moves to dismiss for lack of jurisdiction. For the reasons below, dismissal is denied and some provisional relief is granted. So already we have something. Some provisional relief, not all provisional relief. And we will get into that in a little bit, but to kind of preview it, essentially the way I understand this ruling is that people who currently have DACA, they can apply to renew, but no new DACA applicants will be processed. So essentially, the people who already have this, they would suffer irreparable harm. People who haven't even applied yet, they suffer no harm, so therefore relief would not be justified in that case. So keywords like this, some, must, shall, these are words we're going to look for. Okay? So, statement. This is basically a statement of the facts. In 2012, the United States Department of Homeland Security, DHS is what I'm going to refer to it, adopted a program to postpone deportation of undocumented immigrants brought to America as children and pending action in their cases, to assign them work permits, allowing them to obtain social security numbers, pay taxes, and become part of the mainstream economy. This program received the title Deferred Action for Childhood Arrivals, DACA for short. In 2017, however, after the national election change in administrations, the agency eventually reversed itself and began a phase-out of DACA. All agree that a new administration is entitled to replace old policies with new policies so long as they comply with the law. One question presented in these related actions is whether the new administration terminated DACA based on a mistake of law rather than in compliance of the law or with the law. So, again, I haven't read this. We'll get into this more. But essentially, what this is stating is that immigration law is administrative. And yes, the president has the right to change policies and replace old policies. But when you replace the policy, you have to do it through legal means. And the new policy can't be unconstitutional. I don't think this is one of those things where we're arguing that it was unconstitutional. In fact, I doubt that that is what's in here, but rather that it's simply they didn't do it the right way. From the news reports I've read on this, it appears that they may have done this in what is considered an arbitrary and capricious way. And that's administrative law. Basically, administrative decisions can't be made in an arbitrary and capricious way. There has to be some type of factual underpinning on why they do that. But, as I said, preview for a little bit later if I understood the news reports correct. That's why we're going through this together. History of deferred action. At the core of these cases is an administrative practice known as deferred action. A primary question presented concerns the extent to which the Department of Homeland Security could lawfully use deferred action to implement DACA. and so it is important to review the history of deferred action as well as other features of the DACA program. Congress has the constitutional power to establish a uniform rule of naturalization. Article 1, Section 8, Clause 4. That's of the Constitution, by the way. Pursuant thereto, Congress has established a comprehensive scheme governing immigration and naturalization through the Immigration and Nationality Act, INA. I have a copy of it somewhere here. And we can go through those a little bit later, but it's through 8 U.S.C. Section 1101 and sequential. The Secretary of Homeland Security is charged with the administration and enforcement of the INA and all other laws relating to the immigration and naturalization of aliens. 8 U.S.C. Section 1103A1. The Secretary is further charged with establishing national immigration enforcement policies and priorities. 6 U.S.C. Section 202(5). I should back up because some people may not know how we read law. So when or do citations in law. So when we do citations, it is a full sentence, period, and the citation is its own sentence right here. But this applies to the preceding. So 8 U.S.C. Section 1103A1 is for this sentence. 6 U.S.C. 202(5) is for this sentence. I just want to clear that up as we go, make sure everyone's on the same page so we can go through this. Okay. One of the key enforcement tools under the INA is removal, i.e. deportation. In turn, a principal feature of the removal system is the broad discretion exercised by immigration officials. This is Arizona v. United States, 567 U.S. 387 at 396, 2012. That was a case dealing with Arizona attempting to enforce immigration law on their own, essentially, if I remember that case correctly. One of the things we got out of that was that Arizona, states can't have any immigration law, period. Arizona, in that case, I believe they were trying to implement INA, a form of INA, an exact copy as state law, and that was ruled unconstitutional because of supremacy clause. I digress. As an initial matter in any given case, immigration officials must decide whether it makes sense to pursue removal at all. At each stage of the removal process, they have discretion to abandon the endeavor. Beginning as early as 1975, one way to exercise this discretion became deferred action. By deferred action, immigration officials could postpone seemingly indefinitely the removal of individuals unlawfully present in the United States for humanitarian reasons or simply for the executive's own convenience. I should note, id just means it's the same as the last one. So when you see id, just go back up, and that's your citation. Immigration officials could also grant parole, temporary protected status, TPS, deferred enforced departure, or extended voluntary departure. Some of these discretionary powers have flowed from statute. Parole, for example, has allowed otherwise inadmissible aliens to temporarily enter the United States for urgent humanitarian reasons or significant public benefit. Temporary protected status, also created by statute, has been available to nationals of designated foreign states affected by armed conflicts, environmental disasters, and other extraordinary conditions. An example of TPS that was just ended was for Ecuador. I believe it was just ended, according to the news reports I had seen. And for Syrians, there's temporary protected status for Syrians because of the civil war in Syria. And I dealt with that a lot in law school. Some of these discretionary powers, however, have flowed from non-statutory powers. Deferred enforcement Departure has no statutory basis, but instead grew as the President's constitutional powers to conduct foreign relations. Nor has extended voluntary departure been anchored in any statute. Rather, it has been recognized as part of the discretion of the Attorney General. Deferred action, originally known as non-priority status, also began without express statutory authorization, but has since been recognized by the Supreme Court as a regular practice. Congress has also acknowledged deferred action by explicit reference to it in the INA. Another federal statute, the Real ID Act, I believe this was from 2005, also acknowledged deferred action. This law provided that states could issue a temporary driver's license or identification card to persons who can demonstrate an authorized stay in the United States. Basically what this means is that if you're a non-priority status or you have deferred action, you don't have lawful status per se. It's not a pathway to citizenship or anything, but you are authorized to stay as long as you have that status. It's a little bit nuanced, but essentially just think of it, if you have this, you're authorized to stay here until it's done. But once it's done, and it can be ended pretty much any time as long as it's done properly, you're authorized to stay. Once it's done, though, you have to leave. Persons with approved deferred action status were expressly identified as being present in the United States during a period of authorized stay for the purpose of issuing state identification cards. Congress has also given the executive branch broad discretion to determine when non-citizens may work in the United States. So the way I'm going to show you this as well. You have the case, and then C, this is the statute, and then this bit is what's said in the statute. Sometimes it's an exact quote, sometimes it's a paraphrase. This is all one citation, though. Just information in case you're new to reading a legal opinion. Pursuant to this statutory authority, regulations promulgated in the 1980s allowed recipients of deferred action to apply for work authorization if they could demonstrate an economic necessity for employment. Basically, if you're going to stay here, you can get work authorization as long as you're authorized, but you have to show that you need it. For instance, I can stay here, but if I don't work, I'm going to starve, or I'm going to be a public charge, would be a better way of saying it. Basically, if I don't work, I'm going to have to enroll in welfare programs. That's not allowed under the INA, except for in very, very limited circumstances. So it is better to allow me to work rather than have me be a public charge, which is against the law. So that's kind of how that goes. The George W. Bush administration began to use deferred action to mitigate a harsh statutory provision involving unlawful presence. The Illegal Immigration Reform and Immigrant Responsibility Act, IRA, we have very weird acronyms, IRA in this one, of 1996 created 3- and 10-year bars on the admission of aliens who departed or were removed from the United States after periods of unlawful presence of between 180 days and 1 year, or more than 1 year, respectively. Basically, if you are here unlawfully between 180 days and 1 year, you are barred under IRA from admission for 3 years. If you are here unlawfully for more than 1 year without a waiver, you are barred for 10 years before you can be admitted. Okay. It also imposed a permanent bar on the admission of any alien who, without being admitted, entered or attempted to re-enter the United States after having been unlawfully present for an aggregate period of more than 1 year. Beginning in 2007, however, DHS regulations and policy guidance provided that deferred action recipients did not accrue unlawful presence for the purposes of INA's bars on re-entry. That's important. If you have temporary protective status, TPS, if you have DACA, you are not accruing unlawful presence, even though you may not have entered with a visa. That is very, very important in respect to these bars. So that's IRA 1996. Really tough, really strict immigration reform. That 2007 under Bush, that was actually a really good thing. It didn't completely solve issues, but it did mitigate it. Memorandum, right, we're starting down here. DHS excluded recipients of deferred action from being unlawfully present because their deferred action is a period of stay authorized by the government. This non-accrual practice arose well before DACA. And you can see here, undocumented aliens do not begin to accrue unlawful presence for the purpose of Section 1182A9B1I, until they reach the age of 18. Basically saying that as long as you're under 18, you don't accrue unlawful presence. That's why DACA recipients, they often don't have unlawful presence because they were brought here as children. They didn't start accruing it until they reached the age of 18. DACA grew out of a long agency history of discretionary relief programs. In 1956, the Eisenhower administration paroled roughly 1,000 foreign-born orphans who had been adopted by American citizens. And I'm going to skip a lot of this just for the interest of time. I will link everything. You can go through and read. But this is just a long history. I want to get to... here's the history of DACA. These are the facts for DACA. Starting on page, where is it? 6. Starting at the bottom of page 6 and going through 9. Here's the controversy with DAPA, where part of DAPA was ruled unconstitutional, and DACA came from that. Rescission of DACA. These are the facts. These are the facts that we need. A lot of our facts will be needed in here, but these are the operative facts, I would think, because this has to deal with the actual rescission. So we're going to start on page 12, rescission of DACA. Also, in June 2017, 10 of the 26 plaintiffs from the DAPA litigation wrote to Attorney General Jeff Sessions to demand rescission of the 2012 DACA memo. Their letter stated that if DACA was rescinded by September 5th, they would dismiss the still pending DAPA litigation. Otherwise, the letter threatened to try to amend their complaint to additionally challenge the legality of DACA. A day before the deadline, the Attorney General advised Acting Secretary of Homeland Security Elaine Duke via a short letter that the Obama administration had created DACA without proper statutory authority and with no established end date, after Congress repeated rejection of proposed litigation that would have accomplished a similar result, and that therefore the program was an unconstitutional exercise of authority by the executive branch. The Attorney General's letter also referenced the preliminary injunction against DAPA, then stated that because the DACA policy has the same legal and constitutional defects that the courts recognized as to DAPA, it is likely that potentially imminent litigation would yield similar results with respect to DACA. The following day, without prior notice, the acting secretary rescinded DACA. The rescission was not based on policy criticism. Instead, it was based on legal determination by the Attorney General. This is extremely important because, like I said earlier, it has to be based on something. It cannot be arbitrary and capricious. So, this wasn't based on a criticism of the policy, but instead it was based on a legal determination. So if that legal determination is not accurate, if that legal determination is false, then the rescission based on that legal determination is arbitrary and capricious, or could be. If it was based on actual policy criticism, then that, even if you don't agree with it, that might actually hold up to the arbitrary and capricious way, as long as there's something supporting. Arbitrary and capricious is not that high of a burden. So, anyways, we'll continue after I drink something real quick. I'm sorry, I'm very thirsty. The acting secretary explained that after taking into consideration the Supreme Court's and the Fifth Circuit's ruling in the ongoing litigation and the September 4, 2007 letter from the Attorney General, it is clear that June 15, 2012 DACA program should be terminated. She said that, recognizing the complexities associated with winding down the program, DHS would provide a limited window in which it would adjudicate certain requests, but that new DACA requests and applicants for employment authorization would be rejected starting immediately. DHS would adjudicate on a case-by-case basis. DACA renewal requests received within 30 days from beneficiaries whose DACA status would expire before March 5th, 2018. She also instructed DHS to immediately stop approving new applications for advanced parole. The rescission left in place all extant grants of deferred action and work authorizations for the remainder of their validity periods. Basically, what that means is if you already had DACA, you kept DACA until it ran out. But according to this, if it ran out after that date or after they stop processing the requests, then it just runs out. You don't get to renew. Consequently, starting in March 2018, the DACA population will, over 2 years, dwindle down to 0. And that's because they can't renew. On the night of the rescission, President Trump called upon Congress specifically to enact DACA, tweeting, "Congress now has 6 months to legalize DACA," something the Obama administration was unable to do. "If they can't, I will revisit the issue." During an interview earlier in 2017, President Trump had stated that we are not after the dreamers, we are after the criminals, and that the dreamers should rest easy. In sum, the new administration didn't terminate DACA on policy grounds. It terminated DACA over a point of law. A pithy conclusion that the agency had exceeded its statutory and constitutional authority. An important question now presented is whether the conclusion was a mistake of law. That's what I was getting at earlier. The instant litigation. Let me just see how long this bit is. So here 18 is the analysis. These are the facts of the current litigation, dealing with why do these people have standing, why is there subject matter jurisdiction. These are the instant These are the facts for this litigation. All this before was history. This is the facts for the litigation. I'm going to skip over them in the interest of time because this is already going to be a really long video, probably because this is a long document. So we're going to skip down to the analysis starting at page 18. I'm going to go ahead and close a 12B1 motion. Motion to dismiss. Defendants raised 3 jurisdictional arguments under Federal Rules of Civil Procedure 12B1. First, they argue that the decision to rescind DACA was a discretionary act barred from judicial review under the APA. That's the Administrative Procedures Act. I apologize. It's been a while since I've looked at the APA, and the name, I think that's the correct name. It escapes me, but I believe it's the correct one. Second, they contend that the INA bars judicial review. There are actually a lot of places in the INA that do have bars on judicial review. You have to look very closely, and you have to understand case law and the structure of it. Third, although defendants concede that individual plaintiffs have standing, they contend that no others do. Each is now addressed in turn. A separate order will consider defendant's motion to dismiss under Federal Rule of Civil Procedure 12B6. This is the one that everyone generally knows. This is the motion to dismiss for failure to state a claim upon which relief can be granted. This is a separate motion, so it's not addressed here. But apparently one was filed. So when that motion comes up, when I find out about it, because I haven't looked yet, I will do a follow-up video and we'll go over the 12B6 motion. DACA rescission was not committed to agency discretion by law. Congress has instructed our district courts to review and set aside agency actions found to be arbitrary, capricious, and abuse of discretion or otherwise not in accordance with law. And that's 5 U.S.C. section 706(2)(a). Under the APA, however, our district courts lack subject matter jurisdiction to review agency action that is committed to agency discretion by law. In Citizens to Preserve Overton Park, Inc. v. Volpe. I could never say that correctly. Overton Park was actually a very interesting case. I suggest you go read it. It's about a bridge to nowhere. The Supreme Court explained that the jurisdictional bar of Section 701A2 is very narrow and applicable in those rare instances where statutes are drawn in such broad terms that in any given case there is no law to apply. The Supreme Court held that because the statute there at issue contained clear and specific directives guiding the agency's decision, there was law to apply, so the exemption for action committed to agency discretion was inapplicable. When it next revisited the exception in Heckler v. Cheney, I think I've read that one, but I don't remember what it is exactly. The Supreme Court reiterated that the exception applies only where the statute is drawn so that a court would have no meaningful standard against which to judge the agency's exercise of discretion. These condemned inmates asked the FDA to bring an enforcement action to prevent purported violation of the Federal Food, Drug, and Cosmetic Act through the administration of death penalty drugs. The FDA commissioner, however, refused to do so on the ground that the FDA lacked jurisdiction and otherwise should not interfere with the state criminal justice system. Skipping over the agency jurisdiction issue, the Supreme Court held that such decision not to prosecute or initiate enforcement actions are generally not reviewable as they are committed to an agency's absolute discretion. Cheney identified several characteristics of non-enforcement decisions as key to its holding. First, non-enforcement decisions require a complicated balancing of factors, peculiarly within the agency's expertise, including whether resources are best spent on this violation or another, whether the agency is likely to succeed if it acts, whether the particular enforcement action requested best fits the agency's overall policies, and whether the agency has enough resources to undertake the action at all. Second, in refusing to act, an agency does not exercise its coercive power over an individual's liberty, and accordingly does not infringe upon areas that courts are often called upon to protect. When an agency does act to enforce, however, the action itself provides a focus for judicial review. Inasmuch as the agency must have exercised its power in some manner. Third, a refusal to institute enforcement proceedings is similar to a prosecutor's decision not to indict, which decision has long been regarded as a special province of the executive branch. Our case is different from Cheney. That is key words right there. This means that they are distinguishing this case from Cheney. Meaning they're about to tell us why all this doesn't apply. There, the agency simply refused to initiate an enforcement proceeding. Here, by contrast, the agency has ended a program which has existed for 5 years, affected 689,800 enrollees, or affecting that many. Importantly, major policy decisions are quite different from day-to-day agency and non-enforcement decisions. Rather, broad enforcement policies are more likely to be direct interpretations of the commands of the substantive statute rather than the sort of mingled assessments of fact, policy, and law that drive an individual enforcement decision. Even defendants concede that the agency's interpretation of a statute is embedded in non-reviewable enforcement policy. The former may be reviewable as such, although they contend that the rescission memorandum does not contain an embedded interpretation of the INA. That assertion is incompatible with the acting secretary's explicit reference to the INA and the Attorney General's determination that DACA was effectuated without statutory authority. The first and third Cheney factors accordingly do not apply to the instant case. So only the second one, which up here, refusing to act, an agency does not exercise its coercive powers over an individual's liberty and accordingly does not infringe upon areas that the courts often are called upon to protect. That's the only Cheney factor that we're dealing with, if any. Cheney is also distinguishable because, unlike there, here the government reversed course after 5 years of inviting DACA recipients out of the shadows. In contrast to the non-enforcement decisions, rescissions of commitments, whether or not they technically implicate liberty and property interests, as defined under the Fifth and 14th Amendments, exert much more direct influence on the individuals or entities to whom the repudiated commitments were made. Through DACA, the government has invited undocumented aliens who met threshold criteria to step forward, disclose substantial personal information, pay a hefty fee, and comply with ongoing conditions, all in an expectation of, though not a right to, continued deferred action. DACA allows enrollees to better plan their careers and live with a reduced fear of removal. DACA work authorizations, for example, allow recipients to join in the mainstream economy and pay taxes. DACA covers a class of immigrants whose presence seemingly all agree pose the least, if any, threat and allows them to sign for honest labor on the condition of continued good behavior. This has been an important program for DACA recipients and their families, for the employers who hire them, for our tax treasuries, and for our economy. An agency action to terminate it bears no resemblance to an agency decision not to regulate something never before regulated. Finally, there is law to apply. The main, if not exclusive, rationale for ending DACA was its supposed illegality. But determining illegality is a quintessential role of the courts. Okay, so I want to go back just real quick, because there seems to be some people who don't understand this. I want to hammer this home a little bit and explain it a little bit. DACA covers a class of immigrants whose presence seemingly all agree pose the least, if any, threat and allow them to sign up for honest labor on the condition of good behavior. The reason that they pose the least, if any, threat is the moment that they commit crimes, the moment they pose a threat, they lose DACA. It's in their interest to not pose any threat. It is in their interest to be the least violent, the least criminal, the most law-abiding of anyone in this entire nation, because the moment they step out of line, they lose DACA, and therefore they get deported. This is especially important because, as is stated up here a little bit earlier, they've given all their information to the government. So the moment they step out of line, government knows everything about them, where to get them, and they're deported. So yes, DACA recipients are the least violent, least likely to commit crimes. There are a couple who may have, but they lost it. So that's just how that program works. Second, this is B. This is their second argument. INA does not bar review. The principle that courts owe substantial deference to the immigration determinations of the political branches is important and undisputed. That difference, however, does not remove the decisions to rescind DACA from the ambit of judicial review. I'm not going to lie, that's the first time I've ever seen ambit as a word. So, rather, the Supreme Court has applied the strong presumption in favor of judicial review of administration action in the immigration context. In this connection, defendants raise two arguments. First, they contend that review of discretionary enforcement decision results in an inappropriate delay of removal and accordingly prolongs violations of our immigration laws. This argument, however, again ignores that plaintiffs do not challenge any particular removal, but rather challenge the abrupt end to a nationwide deferred action and work authorization program. In any individual case, DACA allows DHS to revoke deferred action and to deport. So they're not saying you can't do it individually, you can't do it with the whole program. Second, defendants assert that review of such decisions may involve disclosure of law enforcement priorities and foreign policy objectives. Neither concern is implicated here, as defendants' stated reasons for the rescission all relate to the across-the-board cancellation of DACA based on supposed illegality, not to the facts particular to any proposed removal. Nor does Section 1252G bar judicial review of the agency action in question. 8 U.S.C. Section 1252G provides, except as provided in this section and notwithstanding any other provision of law, statutory or non-statutory, no court shall have jurisdiction to hear any cause or claim by or on behalf of any alien arising from the decision of, or action by the Attorney General to commence proceedings, adjudicate cases, or execute removal orders against any alien under this chapter. As explained by the Supreme Court, this provision applies only to the three discrete decisions or actions named in Section 1252G. Plaintiffs' claims do not involve such decisions, but rather the challenge here is to the across-the-board cancellation of a nationwide program. And we have a footnote here. The district court in Batalla Vidal also concluded that Section 1252G did not bar judicial review of challenges to the DACA rescission. So, we have basically because they're suing over the entire thing rather than just individuals, they have a case so far. I apologize, my mouth gets dry after reading for a while. Defendants recognize that these actions were brought prior to the commencement of any removal proceedings. Nevertheless, they argue that Section 1252G precludes review of plaintiffs' claims because the decision to discontinue deferred action is an ingredient to the commencement of enforcement proceedings. It is true that eliminating DACA draws its enrollees one step closer to deportation, but the Supreme Court rejected the argument that Section 1252G somehow precludes review of the many other decisions or actions that may be part of the deportation process. As AADC emphasized, it is implausible that the mention of 3 discrete events along the road to deportation was a shorthand way of referring to all claims arising from deportation proceedings. Defendants cite 2 decisions. Importantly, however, both stemmed from already commenced deportation or removal proceedings. By comparison, our Court of Appeals has held, following AADC, that Section 1252G does not bar review of actions that occurred prior to any decision to commence proceedings. The claims in Kwai Fong Wong challenged the revocation of the plaintiff's parole without first deciding her application for immigration relief, conduct which resulted in the INS's decision to commence removal proceedings and ultimately to remove. I should note, INS is now known as CIS, USCIS. It was changed, so we don't have INS anymore. That's the Immigration Naturalization Service. That is now the Citizenship and Immigration Services. Contrary to defendants, it is immaterial that Kwai Fong Wong did not involve deferred action, as both the revocation of parole and the revocation of deferred action are an ingredient to the commencement of enforcement proceedings. The jurisdictional limits of Section 1252G were instead directed at the deconstruction, fragmentation, and hence prolongation of removal proceedings. Sorry, I'm hiccups a little bit. C. Most plaintiffs have standing. That means not all of the plaintiffs have standing, but most of them did, which is enough. Not every... The plaintiffs who don't have standing will be dropped from the case, most likely. So that's how that works. Oh, good. We get into explaining how people have standing. Standing's basically just, can you bring something to the court, and they do give you the actual elements of it. To establish standing, Article 3 of the United States Constitution requires plaintiffs to show they suffered an injury in fact that is fairly traceable to the challenged conduct of the defendant and that is likely to be redressed by favorable judicial decision. The standing inquiry is focused on whether the plaintiff has a sufficient personal stake in the outcome of the controversy to ensure that parties will be truly adverse in their legal presentations sharpened. Basically, we don't want people bringing suits and then kind of playing along with the other side. Our entire legal system is based on adversarial conflict. We have a very adversarial legal system. Therefore, we want conflict. We want it to be adverse, because the more adverse, the more in conflict it is, the sharper the legal arguments are, the better the legal arguments are, and therefore the better the law that comes out of the decision. Wanting conflicts does not mean that you need to be mean, rude, vile to the other side, but simply that there needs to be some type of fight, legal fight. If the plaintiff suddenly just sides with the defendant, well, there's no adversarial thing, there's no controversy essentially, and therefore there's no standing. So that's kind of how standing works. Standing must be assessed on a claim-by-claim basis, meaning that every plaintiff has to have standing. Defendants do not dispute that the individual plaintiffs have standing. Rather, they argue in brief that the entity plaintiffs, the state and local government, UC plaintiffs, and SEIU Local 521, lack Article 3 standing because the rescission does not regulate or restrict them in any way. Defendants therefore posit that the entity plaintiffs' claimed injuries are due only to incidental effects of the rescission, which defendants contend are insufficient to establish injury in fact. As set forth below, these arguments lack merit. So basically what they're saying is that the non-individual plaintiffs, they're not actually affected by this. They're only incidentally affected, and therefore they can't sue based on incidental effect. The court's saying they lack merit, so let's find out why. First, California, Maryland, the city of San Jose, and the county of Santa Clara each employ DACA recipients in connection with whom they have invested substantial resources in hiring and training. Plaintiffs allege that they will not only lose these employees as work authorization expires, but that they will also need to expend additional resources to hire and train replacements. San Jose further alleges that as a result of the rescission, the city has had decreased productivity. Excuse me, I'm sorry. And that it has had to expend time and resources to deal with decreased employee morale. Second, plaintiff states, including Maine and Maryland, stand to lose significant tax revenue as a result of the rescission, although general allegations of injury to a state's economy and associated decline in general tax revenues may not be sufficient to establish standing. Here, plaintiff states sufficiently allege a direct injury in the form of loss of specific tax revenues. They allege, for example, that Maine stands to lose $96,000 in annual state and local taxes as DACA recipients leave the workforce. Evidence submitted by plaintiffs support these allegations and demonstrates that DACA's rescission would reduce state and local tax contributions by DACA-eligible individuals by at least half. Third, the University of California has also established that it will suffer injury to its proprietary interests. As declarations submitted by the university demonstrates, the rescission has harmed the university in multiple ways. Because DACA recipients can no longer seek advanced parole, these students are unable to travel outside the United States for research and educational conferences. DACA recipients have also decided to cancel their enrollment in the university, and additional recipients are at risk of dropping out because they would not be able to pay the cost of attendance without work authorization. The university has also invested resources in recruiting and retaining DACA recipients as employees in various roles, including as teaching assistants and healthcare providers. Such investments would be lost should these employees lose their ability to work in the United States. California, Maryland, and Minnesota also allege injury to their public universities through harm to their educational missions and the loss of students and teachers. According to the declarations filed by plaintiffs, the rescission resulting loss of work authorization and potential deportation will adversely impact the diversity of the talent pool of potential students, which will make it more difficult for the universities to fulfill their missions of increasing diversity. Our Court of Appeals recently affirmed that standing of two state governments to challenge an immigration policy that similarly harm the plaintiff's public universities. These are Washington v. Trump, or this is Washington v. Trump. 847 Federal 3rd, 1151 at 1160 through 1161. No, through 01. Huh. 9th Circuit, 2017. These injuries, accordingly, give the University of California and the State of California, Maryland, and Minnesota Article 3 standing. Fourth, state plaintiffs Maryland and Minnesota further allege that the rescission will negatively impact their public health programs. In particular, Maryland and Minnesota allege that rescinding DACA will cause many DACA grantees to lose their employer-based health insurance, imposing higher healthcare costs on the state. These injuries are also sufficient to confer Article 3 standing. Finally, SEIU Local 521 has associational standing to bring its claims on behalf of its members who are DACA recipients. An association has standing to bring suit on behalf of its members when 1. Its members would otherwise have standing to sue in their own right, which means the individuals need standing, and 2. The interests it seeks to protect are germane to the organization's purpose, so they have to be, there has to be an interest to the organization. And 3, neither the claim asserted nor the relief requested requires a participation of individual members in the lawsuit. SEIU has established all 3 elements here. SEIU has members who are DACA recipients. Its constitution states that part of its mission is to provide its members with a voice in the larger community, and that its members should be treated equally and with dignity regardless of immigration status or national origin. SEIU has also formed a Committee on Comprehensive Immigration Reform, a member-based committee that engages in organizing, advocacy, and education to help undocumented workers. Its members' interests in these actions are therefore germane to SEIU's stated purpose. Furthermore, this action does not require the participation of SEIU's individual members. Defendants, in arguing that the entity plaintiffs lack standing, rely solely on Linda R.S. v. Richard D., 410 U.S. 614 at 619, 1973. There, the plaintiffs lack standing to challenge a Texas court's interpretation of a child support statute. The Supreme Court held that although the plaintiffs had alleged an injury, she had not shown a direct nexus between the vindication of her interest and the enforcement of the state's criminal laws. Because the relationship between the state's decision not to prosecute the father's decision not to pay under the statute could, at best, be termed only speculative. As explained above, the entity plaintiffs have alleged harm to their proprietary interest as a direct result of defendants' decision to terminate the DACA program, most notably through its termination of work authorizations. Accordingly, the entity plaintiffs have sufficiently alleged injury in fact traceable to the I'm getting a little bit tongue-tied. Traceable to the termination of DACA, and have demonstrated that these harms are redressable by their requested relief. Basically, redressability means can the court actually grant some type of relief? Because if the court can't redress a grievance, if they can't grant some type of relief, there's no point in having the lawsuit. Think of it that way. Give me just one moment. I'm getting a little bit tongue-tied here. I do apologize for the pauses. We're gonna skip some of this decision because most of this is on standing. What I wanted to get to is this part, the provisional relief. Because all of this is just saying, yeah, you can sue. This provisional relief actually has an effect. So, oh good, they've broken it down like they should have. It's a judge, I expect good legal writing. Let me see exactly how long this is. There's the scope, there's conclusion, there's certificate. Alright, so this is just going to be the rest of this document. We were on page 28. So we got about 21 pages to go. Count as 20. Alright, provisional relief. Plaintiffs seek a preliminary injunction to restore DACA. To support a preliminary injunction, plaintiffs must establish 4 elements, and these are very important elements. 1. There must be a likelihood of success on the merits. 2. There must be an irreparable harm in the absence of preliminary relief. 3. The balance of equities tips in their favor. And 4. The injunction is in the public interest. As now explained, the record warrants most of the provisional relief requested. So let's see. So the right here it says what it is: restore DACA. When they say most, this is why they don't get everything, but they do get some. I just wanted to see if they'd split it up there, and I missed it, but I didn't. Alright, likelihood of success on the merits. And this is going to get into the actual case of why this is allowed, why they reinstated part of DACA. Plaintiffs have shown a likelihood of success on their claim that the rescission was arbitrary, capricious, and abuse of discretion or not otherwise in accordance with law. I want to note right now, that does not mean that the plaintiffs have won on the merits. It only shows that there's a likelihood of success. Okay? That doesn't mean that it was in fact arbitrary, capricious, or an abuse of discretion, or not otherwise in accordance with law. It does not mean that the plaintiffs win the overall lawsuit. It does not mean that DACA will in fact be reinstated permanently or whatever is ultimately wanted. All it means is that the plaintiffs have shown enough evidence that we are going to maintain the status quo while this lawsuit goes forward. Okay? Specifically, plaintiffs are likely to succeed on their claims that the agency's decision to rescind DACA was based on a flawed legal premise, and 2, the government counsel's supposed litigation risk rationale is a post hoc rationalization and would be, in any event, arbitrary and capricious. Rescission was based on a flawed legal premise. The agency action was not in accordance with law, because it was based on the flawed legal premise that the agency lacked authority to implement DACA. When agency action is based on a flawed legal premise, it may be set aside as arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law. This order holds that DACA fell within the agency's enforcement authority. The contrary conclusion was flawed and should be set aside. The administrative record includes the 2014 determination of the official legal of the Office of the Legal Counsel of the United States Department of Justice that programmatic deferred action is a permissible exercise of DHS's enforcement discretion. OLC, that is the Office of Legal Counsel, that's the abbreviation. OLC noted that deferred action programs such as DACA are permissible so long as immigration officials retain discretion to evaluate each application on an individualized basis and so long as the concerns animating the program were consistent with the types of concerns that have customarily guided the exercise of immigration enforcement discretion. OLC recognized that the practice of granting deferred action dated back several decades, and the Congress has long been aware of the practice of granting deferred action, including in categorical variety and of its salient features. And it has never acted to disapprove or limit the practice. Indeed, not only has Congress not limited the practice, but has enacted several pieces of legislation that have either assumed that deferred action would be available in certain circumstances, or expressly directed that deferred action be extended to certain categories of aliens. I'm going to zoom in real quick. I just realized how small that might have been for everyone. I apologize. I should have done that 30 minutes ago. Alright. As explained in OLC's opinion, each feature of DACA program is anchored in authority granted or recognized by Congress or the Supreme Court. Because this is the heart of the problem, and with apology for some repetition, this order will now examine each feature in turn. The Secretary of Homeland Security is responsible under the INA for establishing national immigration enforcement policies and priorities. The Secretary is also charged with the administration of enforcement of the INA. In making immigration enforcement decisions, the executive considers a variety of factors, such as danger posed to the United States of an individual's unlawful presence, the impact of removal on the state, on the nation's international relations, and the human concerns of whether the individual has children born in the United States, long ties to the community, or a record of distinguished military service. In instituting DACA, Secretary Napolitano explained that the program was necessary to ensure that DHS's enforcement resources are not expended on low-priority cases, but are instead appropriately focused on people who meet our enforcement priorities. I apologize. You may hear the sound of feet, of paws. My ferret just woke up, and he's running around. Come here, buddy. Come here, little buddy. He will be running around for a bit, so he you might hear this little fuzz butt. Hi, buddy. All right, say hi to the people. Hi, people. All right, go run while I finish this up. There you go. Sorry about that. He can just be loud, so I want to apologize in advance. As set forth, deferred action originated without any statutory basis apart from discretion vested by Congress in connection with the agency's enforcement of the immigration laws. Over the decades, however, deferred action became such a fixture that Congress referred to it by name in several INA amendments. And then we'll go through each of those. Even the U.S. Patriot Act. Congress has been free to constrain DHS's discretion with respect to granting deferred action, but it has yet to do so. The Supreme Court has recognized the authority of DHS to grant relief from removal, and has specifically recognized deferred action as a way to exercise that discretion for humanitarian reasons or simply for the executive's own convenience. Notably, our Court of Appeals has said that the exercise of prosecutorial discretion in deferred action flows from the authority conferred on the Secretary by the INA. In extending programmatic deferred action to DACA enrollees, the agency acted within the scope of this long and recognized practice. I'm going to skip a little bit ahead. again, interest of time is why we're doing this. Basically, what this is saying, as I'm skimming this, is that that DACA was based in the authority vested to the executive branch. Therefore, there is a legal basis for DACA. Significantly, the government makes no effort in its briefs to challenge any of the foregoing reasons why DACA was and remains within the authority of the agency. Nor does the government, in any of the statutes and regulations under which deferred action recipients obtain the foregoing benefits. Instead, the administrative record shows that the Attorney General told the acting secretary that DACA was illegal. First, the Attorney General said that DACA had been improperly adopted by the Obama administration after Congress repeated rejection of the proposed legislation that would have accomplished a similar result. But the proposals rejected by Congress markedly differ from DACA. Importantly, while the proposed legislation would have offered Dreamers the ability to become lawful permanent residents, no comparable pathway was offered by DACA. So basically, what it's saying is, yeah, Congress didn't do that, but what Obama did wasn't what Congress rejected. He did something different. Similar, but different. Our Court of Appeals recognized this distinction, noting that the DREAM Act and the DACA program are not interchangeable policies because they provided different forms of relief. That's basically what I just said. In fact, the 2012 DACA memo made explicit that DACA offered no pathway to lawful permanent residency, much less citizenship. Secretary Napolitano concluded her memo by stating that DACA conferred no substantive right, immigration status, or pathway to citizenship. To claim that DACA was rejected by Congress, therefore, is unfair. I want to see this footnote. It's just the congressional record. Second, another criticism of DACA was the applications received mechanical routine approval without individual consideration. In her rescission memorandum, the acting secretary indicated that the United States Citizen and Immigration Services, USCIS, has not been able to identify specific denial cases where an applicant appeared to satisfy the programmatic categorical criteria as outlined in the original DACA memorandum, but still had his or her application denied based solely upon discretion. The simple answer to this, if true, would be for the agency to instruct its adjudicators to exercise discretion on an individualized basis to make sure applicants do not pose a threat to national security or public safety and are otherwise deserving of deferred action. Basically, instead of ending the entire program because USCIS does not use discretion, they could have simply ordered USCIS to start using discretion. That would have been sufficient. But they went above and far beyond. It appears, moreover, that the acting secretary was in error when she said that USCIS has been unable to identify discretionary denials of DACA applications. She cited no evidence for this fact, and none is found in the administrative record. Possibly, the acting secretary relied on findings made in the DAPA litigation. Therefore, the majority panel noted that USCIS could not produce any applications that satisfied the guidelines of the original DACA memorandum, but were nonetheless refused through an exercise of discretion. As a dissent pointed out, however, The district court may have conflated rejections of DACA applications with denials, and as a result suggested that most denials were made for mechanical administrative reasons. A declaration submitted in that case by several instances of I skipped something. A declaration submitted in that case by Donald Neufeld, then Associate Director of Service Center Operations for USCIS, pointed to several instances of discretionary denials. That same declaration explained that while a DACA application was rejected when it was determined upon intake that the application had a fatal flaw, an application was denied when a USCIS adjudicator, on a case-by-case basis, determined that the requester either had not demonstrated that they satisfied the guidelines for DACA, or when an adjudicator determined that deferred action should be denied even though the threshold guidelines were met. And again, USCIS has huge amount of discretion. In fact, USCIS can and does reject applications for all types of things, even when the application is perfect and even when all criteria are met. USCIS has a huge amount of discretion. That's why there's no such thing as a 100% success rate in immigration law, because through no fault of the client, no fault through the lawyer, no fault of the application, it can still be denied. So that's, I just want to point that out since it was pointed out right here. Give me 1 second. I'm going to pour more soda because I'm dying of thirst. I do apologize, but this is all done in one take, and it is hard to read out loud for an hour without getting dehydrated. So I do apologize for that. The United States District Court for the District of Columbia, in addressing nearly identical statistics, recognized the distinction. The District Court noted that as of December 2014, 36,860 requests for deferred action under DACA were denied, and another 42,632 applicants were rejected as not eligible, and concluded that such statistics reflected that case-by-case review is in operation. The administrative record tendered in our case completely fails to explain this apparent discrepancy. Third, the main ground given by the Attorney General for illegality was the Fifth Circuit's decision in the DAPA litigation. DACA, the Attorney General said, suffered from the same legal and constitutional defects leveled against DAPA in Texas v. United States. Upon consideration of the full history of that case, however, this was an overstatement. In the DAPA litigation, the District Court held that DAPA violated the APA's notice and comment procedures because it constituted a new rule that substantially changed both the status and employability of millions, and inflicted major costs on both state and federal government. The District Court found that the discretionary aspects of DAPA were merely pretext, based on its finding that DACA had been implemented in such a mechanical way as to prevent the exercise of discretion on a case-by-case basis, and DAPA would therefore be implemented in the same manner. Notice and opportunity for public comment, it held, should have accordingly been given. Although the Fifth Circuit recognizes there was conflicting evidence on the degree to which DACA allowed discretion because the government had failed to produce any applications that satisfied all of the criteria but were refused deferred action by an exercise of discretion, it was not error, clear or otherwise, for the District Court to have concluded that DHS had only issued denials under mechanical formula. The appellate court also pointed to DACA's operating procedures, which contain nearly 150 pages of specific instructions for granting or denying deferred actions, as was supporting the conclusion that DACA did not leave the agency free to exercise discretion. It cautioned, however, that for a number of reasons, any extrapolation from DACA must be done carefully. In particular, the appellate court recognized that DACA involves self-selecting applicants, and those who expected to be denied relief were unlikely to apply. The court also recognized that DACA and DAPA are not identical, and that because eligibility for DACA was restricted to a younger and less numerous population, DACA applicants were less likely to have backgrounds that would warrant a discretionary denial. In addition to affirming the notice and comment holding over one dissent, two of the judges on the Fifth Circuit panel went a large step further and held that DAPA conflicted with the INA. The majority pointed out that the INA already had specific provisions through which aliens could derive lawful status from the children's immigration status. DAPA, the majority said, circumvented this statutory pathway. I'm going to skip a little bit ahead. Basically, it's just saying why the Fifth Circuit in that case rejected various arguments on DAPA. While at least some of the majority's reasons for holding DAPA illegal would apply to DACA, fairness requires saying that DACA and DAPA were different, as the panel opinion stated. An important criticism against DAPA would not apply against DACA, namely the fact that Congress had already established a pathway to lawful presence for alien parents of citizens, so that DAPA simply constitute a more lenient substitute route. DACA, by contrast, has no such analog in the INA. And there is a difference between 4.3 million and 689,800. Finally, the criticism that DACA has been mechanically administered without the exercise of discretion in individual cases, if true, could be fixed by simply insisting on exercise of discretion. In sum, the DAPA litigation was not the death knell for DACA. This order holds that in light of our own Court of Appeals reasoning in Brewer 1 and Brewer 2, in light of the analysis of the Office of Legal Counsel of the United States Department of Justice, and the reasoning set forth above, our Court of Appeals will likely hold that DACA was and remains a lawful exercise of authority by DHS. Plaintiffs are therefore likely to succeed on the merits of their claim that the rescission was based on a flawed legal premise and must be set aside as arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law. And then we'll get it, and this is the alternate. Once we get through this, we may skip a few sections because this video is already extremely long. We'll get to the final order. We might cover a little bit, but after I take a drink. This is the alternative. This is the alternative argument. And basically, the way that works is, alternatives, think of them this way. If the first argument doesn't work, here's our second argument. It shouldn't be, it can be sometimes associated with the first, but oftentimes they are separate. Just think of it that way. Government counsel now advances an alternative rationale for the Secretary's decision to rescind DACA. Counsel contends that DHS acted within its discretion in managing its litigation exposure in the Fifth Circuit, weighing its options and deciding on an orderly wind-down of the program so as to avoid a potentially disastrous injunction in the Fifth Circuit. This, they say, constituted a reasonable judgment call involving management of litigation risks and agency resources. Courts, of course, may not accept post hoc rationalizations for agency action, nor may they supply a reasoned basis for the agency's action that the agency itself has not given. Rather, an agency action must be upheld, if at all, on the basis articulated by the agency itself. Basically, you can't come up with an explanation after the fact. So just think of it that way. The reasons actually given were the illegality. Significantly, the INA itself makes clear that once the Attorney General had determined that DACA was illegal, the acting secretary had to accept his ruling as controlling. So basically, this section is saying that you can't come up with a reason after the fact that's not based on the actual reason. Here's a reference to Chevron. I'll go over Chevron later. It's a very important case in administrative law. The Chevron deference basically means that unless Congress has spoken to an issue, or unless the administration acted in an arbitrary or capricious way, courts will give deference to the government agency and their decision. That's basically what the Chevron deference is. Like I said, I'll go over that in a different video because that is a very important ruling. But basically, this one is saying, in some, government's counsel's alternative spin on the administrative record is just a post hoc rationalization. But even if it had been the actual rationale, it was arbitrary, capricious, and abuse of discretion under Encino Motor. And that was referenced up here. Sorry, I'm trying to get through this a little bit quicker. Irreparable harm. Without reading through this, essentially the plaintiffs are arguing that if you end DACA before this case has been resolved, these people are going to be deported. There's going to be lower taxes. There's going to be harm that you cannot repair. Irreparable harm. You have to have irreparable harm to survive a 12b1 motion. Or not a 12b, sorry, I misspoke. You have to have irreparable harm to get injunctive relief. 12b1 motion is completely different. I was reading and my mouth went a little bit faster than my brain at that moment. One such possibility suggested by plaintiffs is that the rescission was contrived to give the administration a bargaining chip to demand funding for a border wall in exchange for reviving DACA. A presidential tweet after a hearing gives credence to this claim. Another possibility raised by plaintiffs is racial animus. So basically, although plaintiffs are likely to prevail, plaintiffs are entitled to learn all of the flaws, if any more there be, lurking in the whole record. And you have the presidential tweet down here. Balance of equities. On provisional relief motions, district judges must consider whether or not such relief would be in the public interest. On this point, we seem to be in the unusual position wherein the ultimate authority over the agency, the chief executive, publicly favors the very program the agency has ended. In September, President Trump stated his support for DACA, tweeting, does anybody really want to throw out good, educated, and accomplished young people who have jobs, some serving in the military, really? He has also called upon Congress to ratify DACA, tweeting, Congress now has 6 months to legalize DACA, something the Obama administration was unable to do. If they can't, I will revisit the issue. This is a side note for anyone in litigation ever. Watch what you put on social media. Here it's the president, but this applies to everyone. When you're in litigation of any kind, watch what you put on social media, because it can be used against you, and very often it is. This is a good example of social media being used against, even though he's not a direct party. This is definitely a this is a case of social media being used against a party. If he just simply not said this, they wouldn't have had this argument. So be careful with social media. Make sure what you post on Facebook, Twitter, all that stuff, just be careful what you put on, because it can be used against you. Beginning March 5th, absent an injunction, 1,000 individuals per day on average will lose their DACA protections. The rescission will result in hundreds of thousands of individuals losing their work authorizations and deferred action status. This would tear unauthorized workers from our nation's economy and would prejudice their being able to support themselves and their family, not to mention paying taxes to support our nation. 2. Authorized workers will lose the benefit of their employer-provided health care and thus have a greater burden on emergency health care services. So there's the harm that would have been raised up there. Basically, we're saying that it's in the public's best interest not to have that happen while this is going on. Here's the important part. This is the scope. And we're going to read this in full. I'm not skipping through this one, okay? So let me drink something and we'll finish this up. For the foregoing reasons, defendants are hereby ordered and enjoined, pending final judgment herein or other order, to maintain the DACA program on a nationwide basis on the same terms and conditions as were in effect before the rescission on September 5th, 2017, including allowing DACA enrollees to renew their enrollments with the exceptions that new applications from applicants who have never before received deferred action need not be processed, that the advanced parole feature need not be continued for the time being for anyone, and the defendants may take administrative steps to make sure fair discretion is exercised on an individualized basis for each renewal application. Basically, if you've never had DACA before, you can't get it now. The advanced parole feature doesn't have to be continued, and they can deny on individual basis based on fair discretion. So it can't be unfair. Otherwise, DACA is must continue according to this order until this litigation is done. So there's your exceptions, there's your order, but let's continue. Nothing in this order prohibits the agency from proceeding to remove any individual, including any DACA enrollee, who it determines poses a risk to national security or public safety or otherwise deserves, in its judgment, to be removed. Nor does this order bar the agency from granting advanced parole in individual cases it finds deserving, or from granting deferred action to new individuals on an ad hoc basis. Basically, we can give you new individuals can be deferred, can be granted deferred action. They don't have to be, but they can be. The agency shall post reasonable public notice that will resume receiving DACA renewal applications and prescribe a process consistent with this order. The agency shall keep records of its actions on all DACA-related applications and provide summary reports to the court on the first business day of each quarter. This is basically to make sure that they're actually doing what they're supposed to. By way of explanation, while plaintiffs have demonstrated that DACA recipients, as well as their families, schools, employers, and communities, are likely to suffer substantial irreparable harm as a result of the rescission, they have not made a comparable showing as to individuals who have never applied for or obtained DACA. So I mean that's why people who've never applied for DACA and never obtained it, they are not included in this. They're excluded. This order will not require advance parole, unlike the widespread harm to plaintiffs and our economy that would result were the 689,800 DACA enrollees to lose their ability to work in this country. Plaintiffs have not demonstrated that comparable harm will result as a result of DACA recipients' inability to travel abroad. So they can't travel. They can continue to work. They can't travel. I mean, they can if they get advance parole. What advance parole is basically the government saying, yes, you can go here. We're going to let you back in the country. That's what advance parole is. True, individual plaintiffs Jirayut Latvinongskar, I'm sorry, I'm butchering that name, and Norma Ramirez describe professional disadvantages that may result if they are unable to travel internationally. These, however, do not amount to hardships justifying a provisional injunction requiring DHS to resume accepting applications for advance parole. Basically, just because two plaintiffs are going to suffer harm does not mean that everyone will. There's not been sufficient facts to show it. However, as stated, nothing in this order would bar individuals from asking for such agency relief or bar the agency from granting it in deserving cases. Basically, the two plaintiffs can still ask, and they could still be granted, but they're not being required to be granted or anything like that. With respect to geographical scope, this order finds a nationwide injunction is appropriate. Our country has a strong interest in the uniform application of immigration law and policy. Plaintiffs have established injury that reaches beyond the geographical bounds of the Northern District of California. The problem affects every state and territory of the United States. Basically, this is saying that immigration law is federal. It affects everyone. We can't have DACA only apply to people in California. We have to have it. We have to have uniformity. So that's why it applies to the entire nation. In February 2017, our Court of Appeals considered this very issue in Washington v. Trump. That was the first travel ban, I believe, in which it was enjoined, and upheld a nationwide injunction imposed by a single district court, observing that limiting the geographic scope of an injunction on an immigration enforcement policy would run afoul of the constitutional and statutory requirements for uniform immigration law and policy, and that, as here, the government had not proposed a workable alternative. So that's basically what I was saying earlier, and with the addition that if the government hadn't a workable alternative, maybe they wouldn't have done this. Indeed, the Fifth Circuit reached the same conclusion determining the scope of an injunction over DAPA, holding that uniform application of the immigration laws justified a nationwide injunction, so too here. Limiting relief to the states Limiting relief to the states in suit or the individual plaintiffs would result in administrative confusion and simply provoke many thousands of individual lawsuits all over the country. The most practical relief is to maintain DACA in the same manner to which the agency and recipients are accustomed, subject to the exceptions above noted. Basically, this is just saying that we have to maintain uniformity. We're not doing anything new. We're not requiring the government to do anything new. We're leaving exceptions. Simply, the government has to maintain the status quo until the end of this lawsuit, when we actually make a determination on the merits, which this is not. So if you've read that in the news, they're wrong. And I've already seen that argument come up once or twice from very questionable sources, but still I've seen the argument. So this isn't on the merits. This is simply an injunction to maintain DACA. So, in pursuance of this this order, we have the conclusion here, and this is just your certification. It is so ordered. That's my favorite part of every one of these. I'm a lawyer, and I still get a little bit tickled at it. You have the judge. That's the end of the document. So I'm going to go up to the top so you can see this. I'll have this link below this video. What does this mean for people? If there is not an appeal of this decision, and if this appeal is not overturned in a higher court for whatever reason, what this means is, if you are an immigrant who has received DACA already, who has applied for DACA and has already received it and needs to renew, according to this order, DACA must be maintained, and they must allow renewals. If you've never received DACA, you cannot, you can try, but the government is not required to accept new applications, and my bet is that they will not. So if you are one of those that already has DACA and you need to renew, now is the time to put in those applications. Get with an immigration attorney, fill out those applications, get them submitted pursuant to this order. If you have DACA and you need to leave the country, the government is not required to the government's not required to allow you to leave the country. You can apply, no guarantee you'll get it. And as it said, this applies to everyone across the entire United States. Again, this is only provisional relief and denial of a 12b1 motion. There is also apparently a 12b6 motion, which is in a different, something different. Note that this injunction only lasts until the conclusion of this case on the merits. If the 12b6 motion succeeds, which, given that they granted provisional relief, I don't think that they'll succeed on a 12b6 motion. But if they do, for whatever reason, this order will fail. And if the government succeeds, if the defendants succeed on the 12b6 motion, that means they can end DACA, and this means nothing. If the government succeeds on the merits of the base, then they can end DACA, and this means nothing. But this does grant some type of relief, injunctive relief, for people who already have DACA until the conclusion of this case. This was an extremely long video. I apologize. It's a long decision. Most decisions are not this long. But I thought it would be important to go through most of this. We did skip quite a bit. If you want to read the parts we skipped, we can go through that. If you have questions, feel free to ask them, and I'll try to address them at some point. When we get the 12B6 motion, we'll do the same thing, and any other major immigration decisions, we'll probably do the roughly the same thing. But this video is already extremely long. Thank you for dealing with my dehydration and the noises. Thank you for listening and paying attention, and I'll see you in the next video.